Court calls the people of the state of Michigan versus Nathan Philip Willett, case number 25131 SM. Appearances, counsel.
Nate Carnes on behalf of the people.
Alex Thomas on behalf of the defendant, Your Honor.
And the defendant joins us at the table. We are here for a final pretrial conference. Gentlemen, is there an agreement in this matter?
Yes, Your Honor, it's my understanding the defendant will plead no contest to an added count of jostling. The people will dismiss the charged count. It's my understanding the reason for the no contest plea is potential civil liability.
Is that true, Mr. Thomas?
It is, Your Honor.
Mr. Willett, have you heard what the attorney just said the resolution in this matter is?
Yeah.
And is that how you wish to resolve it?
Yes.
The court has been given a copy of, I assume we don't want the amended complaint as part of the no contest packet, so I'm going to remove that.
Very good, Your Honor.
And I will mark the police report received in this matter as exhibit number 1, which is Cadillac Police Department incident number 24003503. Do the people move for its admission?
Yes, Your Honor.
Mr. Thomas?
Yes, Your Honor.
All right. Mr. Willett, will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may put your hand down. It's not that high, is it?
No. I think it's this one. I think it's on.
This one, it's 100. That's what I thought.
And
All
I
right.
do think it has to be.
Oh, that's correct. I apologize. I missed that there had been an amended complaint, so we'll have to, or that he hadn't been arraigned on the amended complaint. So we'll arraign him on the amended complaint first. Mr. Willett, I have an amended complaint that alleges that on or about November 6, 2024 in the city of Cadillac in Wexford County, it is alleged in count number 1 that you did commit the offense of a domestic violence second offense. That is a 1-year misdemeanor and or a fine of $1,000. A consecutive sentence may be imposed if it had occurred in a place of confinement. Do you understand that amended charge and the potential penalties? Mr. Thomas, do you want a moment? Okay. Do you understand those charges and the potential penalty?
Yeah.
All right. I need you to speak right up so we can make sure the recording equipment's picking you up. Okay. All right. All right. We'll go ahead and we'll enter a not guilty plea on your behalf on that amended charge, and we'll move forward. So it's my understanding that you will be pleading no contest to an added count of disorderly jostling. That is a 90-day misdemeanor and a fine of or a fine of $100. Do you understand that?
Yes.
Did you read and sign this advice of rights form? Talk about your rights to an attorney and your rights to a trial. Mr. Thomas, if you want to show that to me.
I read this.
Okay. Do you understand those rights?
Yes.
Do you have any questions for me about those rights?
No.
Most importantly, do you understand that by entering a no contest plea today, you'll be giving up those rights and you won't have a trial of any kind? If you plead today, you won't have a trial. Do you understand that? Does that make sense?
Yeah.
Okay. Yes. Mr. Willett, were you on probation or parole back in November 6th?
No, I don't believe so.
I don't show anything in your past since 2016, so I'm going to say you weren't on probation or parole. And were you on bond then?
No.
All right. Sir, other than the plea agreement, has anybody promised you anything in order to get you to plea today?
It was
was that again? Sorry.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
Um,
Other than the reduced charge, has anybody promised you anything in order to get you to plea?
um,
May I, Your Honor?
You may.
No.
Nobody's promised you anything other than the plea agreement?
Nobody told me to take this or anything. I got advice.
Okay, all right. Has anybody threatened you in order to get you to plea?
Oh, no.
And is it your own free choice to plea?
Yes.
Are counsel aware of any other promises, threats, or inducements to get the defendant to plea today that has not been made part of the record?
No, Your Honor.
None, Your Honor.
Mr. Willett, do you understand that by entering a no contest plea today, I will be reviewing a police report to determine whether or not there's sufficient facts to find that you are guilty of disorderly jostling? And I can also use that police report to impose sentence. Do you understand that?
Yeah.
All right. And again, counsel, the reason for the no contest plea is potential civil liability?
Yes, Your Honor.
Yes, Your Honor.
The court, prior to taking the bench, had been advised of the plea agreement and has had ample opportunity to review the police report. And I find that there is a sufficient factual basis to find the defendant guilty of disorderly jostling. In particular, it alleges that on or about November 6, 2024, in the city of Cadillac, Mr. Willett was walking through the home and pushed Savannah and slapped her and then shoved her off to the side. Others described it more of as a slap to the chest, but she did have red marks on her chest. So for those reasons, the court does find there is sufficient grounds for disorderly jostling. I also find that the interests of justice are well preserved in allowing the defendant to enter a no contest plea today, as a guilty plea could be used against him had there been a civil suit filed in this matter. Do the parties believe that the court has been compliant with the court rules and that the report does form a factual basis?
Yes, Your Honor.
Yes, Your Honor.
As does the court. Again, sir, I find you guilty of disorderly jostling. Can we do sentencing today?
Yes, Your Honor.
Mr. Thomas, any elocution?
Not much, Your Honor. Just that we agree with the people's offer and ask that Mr. Will be sentenced to fines and counsel.
Mr. Carnes?
Thank you, Your Honor. I noted that these individuals were roommates for approximately 2 months. They're not living together anymore, and there was one shove alleged. Certainly, it's disturbing behavior, and I hope Mr. Willett doesn't engage in it in the future. I'll leave sentencing in your discretion. Thank you.
Mr. Willett, is there anything you'd like me to know?
I'd like you to know that I have not done this. In fact, and they are framing me, and I know it, and they know it.
So when I asked you whether or not anybody's forced you to plea and if it's your own free choice to plea today, it doesn't sound like that's necessarily the case.
Well, I guess, I don't know. I don't know what to do.
All right. Under these circumstances, I don't believe the plea is knowing, accurate, or voluntary. So just hold
I
on.
think I just wanted to see.
So I'm going to withdraw and reverse my ruling that there is a finding of guilt in this case. And I'm going to allow the party some more time to see if there's a way to resolve it or decide whether or not there's a potential defense to raise here to go to trial. Under these circumstances, I just don't find that the plea is knowing and voluntary. Okay.
Thank you, Your Honor.
So we'll revisit this one in a little bit. All right, court recalls the people of the state of Michigan versus Nathan Philip Willett, case number 25131 SM. We are back on the record after Mr. Thomas and Mr. Willett have had the opportunity to discuss. Where are we at, Mr. Thomas?
I apologize for the confusion earlier, Your Honor. Mr. Willett often has difficulty with comprehension
Sure.
and begins to panic and will say things. He has confided in me that he intends to accept the plea and has not been threatened or forced in any way, and he will repeat that to the same.
Is that true, Mr. Willett?
Yes.
All right. And you've had ample opportunity to discuss your concerns with your counsel, with Mr. Thomas,
Yes.
and you still wish to proceed with the plea?
Yes.
All right. Mr. Carnes, any comment on that?
No, Your Honor, thank you.
All right. The court will reaffirm then its finding of guilt in this case pursuant to no contest plea. Mr. Willett, you were in the middle of telling me what you'd like me to know about this matter. I will caution you that because this was a no contest plea, Mr. Carnes?
Your Honor, I forgot to mention that people are asking for fines costs only in this matter. That was part of the agreement.
That is part of the agreement?
Yeah, it's just a request. It's not a bill. But I think I need to put that on record. Thank you.
And that's true, Mr.
Yes,
Thomas?
Your Honor. The request for finding the cause is included in the plea offer sheet.
All right. Mr. Willett, I want to back up just a little bit because there's an agreement that I was not aware of. And that agreement is if you were to plead no contest to disorderly jostling, the people would request pursuant to an agreement, fines and costs only. Do you understand that? Does that make sense now?
Yeah.
I might now understand your confusion. So knowing that then, have there been any other promises made to you to get you to plead today?
No.
And nobody's threatened you to plead today?
No.
And it's still your own free choice to plead today.
Yes.
Now, I want to let you know that if I don't go along with that plea agreement for fines and costs, you are able to withdraw your plea. Do you understand that?
Yeah.
Does that make sense to you?
Okay.
Well, I'm asking, does that make sense? So
Yeah.
if I sentence you to more than just fines and costs, you're able to say, nope, hold on, Judge, I don't want to move forward further. I want to withdraw my plea. Do you understand that? Mr. Thomas, you want to help him out?
Your Honor, it isn't a killer agreement we have. It's just the people's offer.
I said it was not a bill, Your Honor. I'm sorry if I didn't say that clearly.
Okay. All right. We are going to start entirely over on this case. All right. Because we have done a sufficient job of muddying this record. So, Mr. Willett, it's my understanding that you're going to plead no contest to an added count of disorderly jostling. Along with that, there's a recommendation from the people that they will request fines and costs only.
Yeah.
That's not necessarily an agreement, but they're going to be their recommendation. Do you understand that?
Yeah.
Okay. Mr. Thomas, is that your understanding of the plea agreement?
It is, Your Honor.
Is there anything else to this?
No, Your Honor.
All right. Mr. Willett, it's my understanding that you will plead no contest to disorderly jostling, which is a 90-day misdemeanor and or a fine of $100. Is that your understanding?
Yes.
All right. And by doing a no contest plea, that will allow me to review the police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing. And that the reason for the no contest plea has been represented to me that it's for civil liability, which means if you were to say, yes, Judge, I'm guilty, if you were to be sued in this matter, the party suing you could use your guilty plea against you. The no contest plea does not allow that to happen. Do you understand that?
Yeah.
All right. So, and we've already gone through, there's no other promises, threats, or inducements. The parties have said there's nothing else on record. So as I've stated before, have already read that police report. And I find that there is sufficient evidence indicated in the police report to find you guilty of jostling. Jostling is no more than just kind of roughhousing, like wrestling in public, if that makes sense. I also find that the plea is knowing, voluntary, and accurate. And we've already done allocution, so we're up to you again. Mr. Willett, as we're moving forward in this, because it was a no contest plea, I want to caution you about saying anything that could be used against you by another party. But you do have the right to address the court, but just realize if you tell me too much about the allegations that could be used against you in another case. Do you understand that?
Yeah.
Okay. Knowing that then, is there anything you want me to know?
Yeah, in the case, it was, okay, I was just saying, like, I'm good.
You're good? All right. Based on the facts of this case as presented in the police report, I do find that fines and costs are appropriate. This was not the crime of the century by any means, so I'm only going to impose what I need to impose pursuant to state law. So there is a $75 crime victims' rights fee and a $50 state minimum fee. So that's a total of $125. Was there any, there's no jail on this case, right?
One day.
I do have to, because you did sit one day in jail, I do have to impose 1 day. So it's 1 day jail, 1 day credit.
Oh, yeah.
All right. So you've
Oh,
sat your time.
oh, okay.
Okay. It's just fines and costs. So that's a total of $125. Can you pay that today?
I can partially pay, I can pay 80 of that today.
All right. So what I'll need you to do is go back out to the front window where you checked in, get a copy of your judgment, and then make that payment. And then you can make payments as you can after that. All right. But I have to tell you that if any balance remains unpaid for more than 56 days, there's a 20% penalty that gets added to that.
Okay,
All right. Do you have any questions for me at all?
no, that was it.
All right. Anything else, counsel?
No,
All right.
No, Your Honor.
Thank you.